Welcome to Easy Learning.
Exercise number 3. The short limited point raised in this revision petition is whether the liability to pay the complainant, that is, the father, nominee of the deceased investor insured, is of the petitioner company or of the insurance company or of both, joint and several. It is not the petitioner company's case that the complainant, rather nominee of the deceased investor, has not to be paid the assured amount. The case professed by the petitioner company is that the liability qua the complainant, father, nominee of the deceased, is only of the insurance company and not of the petitioner company. The death of the deceased occurred in 2007. The complaint was filed before the district forum in 2010. The district forum decided the case in 2016. The appeal was filed before the state commission in 2016. The state commission decided the appeal in 2019. The revision petition has been filed before this commission in 2019. About 12 years have elapsed from the death of the deceased. During arguments, no answer was provided to a question from the bench as to why the respondent number 1 has to wait further. Even after 12 years of the death of the deceased, for the dispute between the petitioner company and the insurance company to be resolved as to which of the two are both are liable to pay the complainant, nominee of the deceased. More so when it is admitted by the petitioner company that it does not dispute that the payment to the complainant nominee has to be duly made. Learned counsel for the petitioner company submits on instructions that even without prejudice to its right to agitate its dispute with the insurance company and to raise all its issues and contentions against the insurance company, the petitioner company is not prepared to pay the complainant, nominee of the deceased. We are but of the considered view that it would albeit be a travesty of justice if the ordinary common consumer, that is, the complainant, nominee of the deceased, has to now, after 12 years of the death of the deceased and after agitating successfully into consumer protection fora, stand arrayed in a third consumer protection forum as respondent number 1 and wait and watch for the petitioner company and the respondent number 2, that is insurance company, to settle their dispute, propose their respective liability towards him. We fail to readily understand what prevents the petitioner company to settle the amount due to the father nominee of its deceased without prejudice to its right to agitate its dispute with the insurance company and to raise all its issues and contentions against the insurance company. We also fail to readily understand what prevents the petitioner company to independently and separately agitate its case with its insurance company without troubling and prejudicing the father nominee of its deceased investor. Therefore, the petitioner is directed to appear before the NCDRC tomorrow, and the petition with all pending applications is hereby disposed of in above terms. Order thusly under the signature of the court master. Full stop.